Hello everyone. This is part second of our earlier video on extraordinary general meetings under section 100 of the Companies Act 2013. So in our previous video we have discussed in how many ways an EGM can be called or can be convened by a company, either by the board suo motu, or by the board on the requisition of the members, or by the members themselves, or by the tribunal. So basically in our earlier video we some points were left to be discussed, like about the important provisions about calling of EGM by the requisitionists themselves, and also about the calling of EGM by the tribunal, that is issuing directions by the tribunal over the company to hold the extraordinary general meeting. So these points we are going to discuss in our video today. So let's proceed with that. Basically, extraordinary general meeting can be either called by the board, or it can also be called by the board on the requisition of the members. So in our earlier video we have already discussed that how many minimum number of members are required to give the requisition for the board to convene the meeting, the extraordinary general meeting. Secondly, the board should proceed within 20 days of the valid requisition to call the meeting, and that meeting should not be held after 45 days of the valid requisition. So the meeting should be held on a day that is not later than 45 days of a valid requisition made by the members. So basically this was the timeline which we have already discussed, and I'm just recapitulating it. And it says if the board fails to call the meeting on such requisition within the given time limit, that is within the 45 days of valid requisition, if the board fails to convene a meeting, then the requisitionists can themselves call the meeting, but that meeting should be held within 3 months of the valid requisition. So now we have to proceed with that provisions only as to when the member themselves call or the requisitionist themselves calls the extraordinary general meeting. So let's start. It says that members may requisition convening of an extraordinary general meeting in accordance with subsection 4 of section 100 by providing such requisition in writing or through electronic mode. Now, first of all, the members can provide the requisition to hold the extraordinary general meeting as per section 100 subsection 4, which means that the member can themselves call the extraordinary general meeting by providing the notice, and that requisition or that notice can be either in writing or it can be through the electronic mode, but it should be made at least 21 clear days prior to the proposed date of such extraordinary general meeting. So whatever be the proposed date of EGM, the requisition of calling it should be made 21 clear days prior to that proposed date. Okay, so the notice have to be given like 21 clear days prior to the proposed date of holding the extraordinary general meeting. So this is similar to as to the provisions of annual general meeting, of calling of annual general meeting, which also we have discussed in our earlier videos. You can refer those videos. So I hope it is clear that the members can give the requisition as per section 100 subsection 4. It can be either in writing or it can be in electronic mode. The important point is it should be at least 21 clear days prior to the proposed date of EGM. Okay, so let's move forward. It says that the notice shall specify the place, date, day and hour of the meeting, and shall contain the business to be transacted at the meeting, which is very simple. Like, notice should tell the place, date, day and hour of the meeting, that is at what time the meeting should be convened, shall be convened, what shall be the date, day, and where will that meeting be convened. All these things have to be have to be disclosed in the notice. And one more important thing, that is what business are to be transacted, it should also be disclosed in the notice. Secondly, it says that this meeting, that is the meeting called by the requisitionist, it should be convened at the registered office or in the same city or town where the registered office is situated. Okay, so this is very important point, because when the board calls the meeting suo motu, then it can be held at any place in India, which is as per SS2, because nothing has been provided in the act. So we'll follow the secretarial standards for general meeting, that is SS2, and in that it has been written, it has been disclosed that the meeting can be held at any place in India. Okay, but the meeting by the requisitionist, it should be convened only at the registered office or in the same city or town where the registered office is situated. Fine. Now, second point is that such meetings shall be convened on any day except national holiday. Okay, so this is like it should be convened on any day, but it should not be the national holiday. It is similar to the annual general meeting, and the in place of national holiday, the term was used early, the term that was earlier used was working day. So in place of working day, now national holiday has been substituted. Okay, let's move forward. Now it says that the notice shall be signed by all the requisitionists or by the requisitionist duly authorized in writing by the other requisitionist on their behalf. So it's clear that the notice should be signed by either by all the requisitionists, or if some of the requisitionists have been authorized on this behalf in writing by the other ones, then they could also sign the requisition or the notice, sorry, and on behalf of the other requisitionists. Okay, so it is not necessary that all the requisitionists should sign the notice. Even if the duly authorized members have signed it, then it would do. Okay, and again, this notice can be either sent on electronic mode. So if it is being sent through electronic mode, then the scanned copy of duly signed requisition needs to be attached. Okay, so it is very important and it is compulsory to sign the notice by all the requisitionists. Okay, so let's move forward. It says that the if the special business is to be convened, then the explanatory statements is required to be attached with the notice. But when the requisitionists are convening their meeting, then this explanatory statements need not be attached. So it has been provided in the act that no explanatory statement as required under section 102 need to be annexed to the notice of EGM convened by the requisitionist, and the requisitionist may disclose the reason for resolutions which they propose to move at the meeting. So they can disclose the reasons, but the explanatory statements need not to be attached with the extraordinary general meeting. But uh, in other kinds of extraordinary general meetings, that is which is convened by the board, then there is a need to attach the explanatory statement, because only for special businesses the EGMs are convened, and for special businesses explanatory statement is also required to be attached to the notice of EGM. But this is the only exception where in for an extraordinary general meeting that is convened by the requisitionists themselves, there is no need to attach the explanatory statement as per section 102 of the act. Okay, so next point is that the notice of the meeting. Now, to who all are the members to whom the notice of the meeting should be given? So it says that the notice of the meeting shall be given to all those members whose name appears in the register of members of the company, which is very much clear. The name of the members which is appearing in the register of member, to all those members the notice has to be given. But as on which date? So it says within 3 days on which the requisitionist deposit with the company a valid requisition. So within 3 days, those name of members which are appearing in the register of members, to all those members the notice of meeting shall be given. Okay. So I hope it is clear that the notice has to be given to the members. Now, who all are the members to whom it is to be given? So it is to be given to all those members whose name is appearing in the register of members. Now, as on which date the name should be appearing? So within 3 days on which the requisitionist deposit the valid requisition with the company for calling EGM. Okay. So now let's move forward. Says that where the meeting is not convened by the board on the requisition of the members, so all the requisitionists have the right to receive the list of members, okay, together with their registered address and number of shares held. So this is why it is because if the board is not convening the meeting on the requisition of the members, then the requisitionists have the complete right to receive the list of members along with the registered address and the number of share, so that they can give the notices to them. Okay. So, and the company is bound to give that list of members together with the registered address made as on the 21st day from the receipt of valid requisition, together with such changes if any, before the expiry of 45 days from the receipt of valid requisition. So it is the duty of the company to give the list of members along with their addresses to the requisitionist, and this list should be prepared as on 21st day from the receipt of valid requisition, because the board, the timeline, I hope you got it from here, that the board shall proceed to convene the meeting within 21 days. So within 21 days, if the meeting is not called, then as on 21st day the list to be prepared and it has to be given to the requisitionists, okay, together with such changes. Now all those changes have to be if any changes occurs in that list, then it is also to be given to the requisitionist within before the expiry of 45 days. Okay, so what all changes that have incurred within before the expiry of 45 days from a valid requisition, then those changes have also to be provided to the requisitionist. Okay, so first of all, if the board does not convene the meeting on the requisition of the members, then the requisitionist have the full right to receive the list of members along with its registered addresses. So, and the company is bound to give that list, and that list has to be prepared as on 21st day of with from the receipt of valid requisition. And if there is any changes in that list, then that has to be given before the expiry of 45 days. So all the changes before the expiry of 45 days on the receipt of uh, re- uh, requisition needs to be incorporated and needs to be given to the requisitionists, so that they can give the notice and they can convene the extraordinary general meeting. Let's move forward. It says that notice shall be given by speed post or registered post or through electronic mode. So all these options are available. Any accidental omission to give notice to or non-receipt of such notice by any member shall not invalidate the proceedings of the meeting. So now, if there is any accidental omission to give the notice to any member, or if any member doesn't receive the notice, then these points will not invalidate the proceedings of the meeting. Okay. Another important point is if the quorum in this meeting, that is called by the requisitionists themselves, if the quorum is not present within half an hour from the time appointed for holding that meeting, then the meeting shall stand cancelled. Okay. Now, if the quorum is not present within half an hour of the from the time that has been appointed for holding this meeting, then the entire meeting shall stand cancelled. So now what is the quorum? We'll be discussing in our next video. I'm not going to discuss it right now, otherwise it would be too lengthy. So as of now, let's move forward. Now, one point that comes into mind is that the members have given the requisition to the board to hold the meeting. Okay. But the board fails to hold that. And so the member themselves calls the meeting. So now what all are the expenses that the member is incurring? As of a logical understanding, the company should bear those expenses. Okay, because it was the responsibility of the board of directors to hold that meeting. But because of their failure to hold this meeting, the members are holding it. The members is convening the meeting on their own. Okay, so now members should be reimbursed with all those expenses that they have incurred in convening the extraordinary general meeting. So now the point says that the extraordinary general meeting that has been called by the requisitionists themselves, all the reasonable expenses that has been incurred by requisitionists in calling such meeting shall be reimbursed by the company to the requisitionist. And one more important point, because it was the default of the directors to not to hold the meeting when there was a requisition by the members. So these expenses should not be borne by the company. It should be borne by those directors who are in default. So that is also provided under section 100 subsection 6, that company in turn recovers such expenses from any fee or other remuneration under section 197 of the act payable to such of the directors who are in default of calling that meeting. Okay, so all those directors who are in default of calling the meeting, any remuneration or fees under section 197 which is payable to them, the expenses shall be recovered from those fees or those remuneration by the company. So in first instance, the company shall reimburse the expenses, reasonable expenses incurred by the requisitionist, but in turn, the company shall recover it from the directors in default. Okay, so let's move forward. Now, second point which we have not discussed in detail in our earlier video was about holding of convening the meeting on the direction of tribunal, which was given under section 98 of the Companies Act, that if for any reason the company is not able to hold the extraordinary general meeting, then the tribunal, either for its suo motu or on the application of the members who have the right to vote, it can order to call a meeting. Secondly, it can also issue certain directions to be complied with in this regard. This we have already discussed in a previous video. Now, what if those directions are not complied by the company? So, if those directions are not complied by the company, or if the extraordinary general meeting is not called, even if the tribunal has ordered it under section 98, then what would be the consequences we'd be seeing here? So it says that every officer of the company and the company itself who is in default, it shall be punishable with a fine which may extend to 1 lakh rupees, and if there is a continuing default, with a further fine which may extend to 5,000 rupees for every day till the default continues. Okay, so this penalty is exactly same, and the section is also same as of the penalty of not holding the annual general meeting. Okay, so what are the penalty? The fine can be extended to rupees 1 lakh, and if there is a continuing default, then there could be an additional fine which may extend to 5,000 rupees for every day during the default continues. Okay, so this is all for the provisions of extraordinary general meetings. I hope you have liked this video, and if yes, then please like and subscribe. My YouTube channel is PH Webgyan Videos. Do not forget to share and comment on this video. Your comments are valuable, so please do. Thank you. Take care. Bye bye.